Welcome to this edition of Legal Peppersoup. I'm your host, Obi Wakeji. Now, unfair dismissal is one of those areas that seems to come up quite a lot in employment law. Somebody's hired, somebody's fired. The person who is fired is not particularly happy in the manner and the circumstances in which they were let go of their job, and therefore are seeking advice, or they seek advice because they feel that the manner in which they were dismissed was unfair. Now, with me in the studio today is Lawrence Jegede, a qualified solicitor who specializes in employment law as well, just to enable us to go through the minefield, which is unfair dismissal. Now, we'll tackle this in a brief sort of outline way because employment law and unfair dismissal in itself are particularly complex and large subject areas. In order to assist, I will read out an email we received recently. It's a client who's made an inquiry through our website, just asking us for some legal advice in relation to a matter. Now, before I proceed, I will say please do not rely on anything you hear that we say during this episode as legal advice for you to rely on. Please cross-check everything with your professional legal services advisor or your local solicitor. If you have any specific questions or queries in relation to anything that you've heard on this show, please email info@ojnsolicitors.com. We'll also leave the details at the end of the program for you to take those details, and you can contact us directly with your specific inquiries in which we'll be able to respond. Now, this email says, I'm a care worker in a care home and have been dismissed by my employer for gross misconduct. False allegations were made against me by a co-worker of not following our required health and safety procedures regarding a resident. My employer did not give me a proper opportunity to defend myself against these allegations. I was made to attend a disciplinary meeting and eventually dismissed. I did not have anybody present with me, and my employer simply repeated all the allegations against me as if they were true. I have worked there since January 2016 and do not believe it is fair for my employer to dismiss me like they did. I would like to sue them for unfair dismissal. Now, what are your thoughts on this email to begin with?
Now, the particulars of this email, they come across as being quite interesting to me from the fact that from what this person has said in the email, the allegations were simply read that, if I recall correctly, she was not allowed to bring somebody to the disciplinary hearing. So as you can tell from that, the procedures were not properly followed. So yes, it might actually be a case of unfair dismissal, but there is a problem here, which it is necessary to point out. That problem is in relation to what is called qualifying period. What that simply means is anybody who wants to bring a claim of unfair dismissal to the tribunal, you have to have a qualifying period of at least 2 years of, being in continuous employment with the same employer. So if you do not have that 2 years continuous employment, then you might not be able to bring a claim of unfair dismissal. And really and truly, we are coming across quite a lot of examples of this simply because employers now know that, look, I can get rid of you for any reason whatsoever, even without reason, because you haven't worked with me for 2 years.
Just hold on, let me stop you there.
Yes.
You're saying that if somebody hasn't been in employment for more than 2 years, they cannot bring an action for unfair dismissal?
There are exceptions, but the general rule is you haven't worked with the same employer for a continuous period of 2 years, then you might not be able to bring a claim of unfair dismissal.
So are you then saying that somebody who has worked in a company, for example, this person here,
yes,
who has worked for 1 year and 3 months,
yes,
can be dismissed unfairly by an employer?
Absolutely. It is possible, and like it or not, it does happen. It is something that we come across every now and then. People who started their employment after April 2012, you are required to have at least 2 years continuous employment with the same employer before you can bring a claim of unfair dismissal.
That doesn't seem quite fair. I mean, so you're saying that somebody can be in employment for 1 year and 9 months,
yes,
and the employer will just dismiss them?
Yes. Again,
without due cause,
without good reasons, without following procedures, without giving reasons for dismissal. It is something that I've come across on numerous occasions.
So the protection only comes in after you've been with an employer for more than 2 years?
For more than 2 years.
So if you haven't worked for more than 2 years, you're not protected?
You're not protected. Again, as I said, there are exemptions to this.
What are the exceptions?
The exemptions mainly, if the reasons for dismissal are, for example, because you're pregnant, because of maternity leave, because of anything in relation to trade union membership or whistleblowing or asserting your right under health and safety regulations. I think there was a mentioning of health and safety regulation.
Well, she says here that false allegations were made following. Well, she says here that false allegations were made against her by a co-worker of not following health and safety procedures.
Yeah. So, those are some of the exceptions. So, if your dismissal has any connection with those factors that I've just mentioned, and then qualifying period, you are exempted from that qualifying period requirements. That means even though you've worked for your employer for less than 2 years, you can still bring a claim of unfair dismissal. Those are the only exemptions. Now there's there is usually another way around this, which is, say for example, if the employee believes that the dismissal has some element of sexual discrimination or harassment, any form of harassment or discrimination, sexual, religious, racial element, and then yes, you must still not be able to sue for unfair dismissal, but you can instead bring a claim of discrimination, harassment, or victimization.
All right. Okay.
So that's another way around it.
So if you are dismissed on those grounds, if you're dismissed unfairly,
yes,
you can't bring the action under unfair dismissal.
Unfair dismissal.
But if it's for one of those reasons, that
you can say, I believe that events leading to my dismissal, or in fact my dismissal itself, was actually an act of sexual discrimination or harassment, or racial one, or religious ones, on the ground of sexual orientation, or other factors like that. Then, even though you cannot bring a claim of unfair dismissal, but those are the claims that you are potentially able to bring against your employer, your previous employer, by the way. Yes.
All right. I've heard this term called wrongful dismissal. What is the difference between wrongful dismissal and unfair dismissal?
The key difference really is wrongful dismissal. Of course, before an employer is able to dismiss an employee, they should give notice to say your last day of employment is in a week, is in 2 weeks, something like that. Or it might not even be in the case of dismissal. Maybe they just want to terminate the contract of employment. The law requires that appropriate notice is given depending on the length of service. For example, it could be a 1 week notice, 2 weeks notice, 3 week notice. It really depends on the length of service or contractual times of of your employment with your employer. Now, if the employer fails to give the required notice, then that constitutes wrongful dismissal.
And what can you do from that?
Well, you can also bring a claim of wrongful dismissal to the tribunal, and of course seek appropriate compensation for that. Now, that is the key difference between unfair dismissal and wrongful dismissal. Wrongful dismissal, it doesn't really have to do with, I was dismissed because of my conduct or capability or anything like that. It is simply your employer finding any reason whatsoever to say we want to terminate the contract of employment, and of course they should give notice before they do that. But of course, some employers can say, instead of giving you notice, we will pay you instead of notice. If they can do that without giving you the notice, they've offered to pay instead of giving you the notice, then they've covered that notice period. So they will not be liable to any allegation of wrongful dismissal.
Is there a time limit in which somebody has to bring an action for unfair dismissal? So, say for example, not in this case because this person clearly doesn't qualify to bring an action in unfair dismissal. We don't know what the circumstances are behind that.
Yes.
But is there a time limit from the time you're dismissed, from the time you can bring an action? And if you can bring an action, where do you bring the action? In
the case of unfair dismissal, the time limit is 3 months, but one needs to be careful about that. 3 months is usually 3 months minus 1 day. So you have to be aware of that minus 1 day.
Is that 3 calendar months?
3 calendar months, yes. Minus 1 day. But there's been a slight change introduced by the government not too long ago, whereby before you can easily bring your case of unfair dismissal to the tribunal, but now they brought something, some slight change, whereby you have to go to or through ACAS before you can bring your claim of unfair dismissal
ACAS,
to the tribunal.
ACAS stand for?
ACAS, that is the Advisory Conciliation and Arbitration Service. Is a government independent, free guidance provider. They're there to help both employers and employee to see whether they can resolve their dispute without actually going to court or to the tribunal.
So what you're saying is that if you have a grievance against an employee, you can't just simply go and
no, you cannot
what
just
happens?
issue anymore. So you need to go to these ACAS guys first and say,
Yes.
look, I have this problem with my employer or my previous employer. They will ask you questions, about what your, they will get the facts from you, speak to the employer and see whether the matter could be resolved without going to the tribunal. Now, if there is no resolution to the dispute, ACAS will then give you a certificate, because then you need a certificate number to bring a claim to the tribunal. But the thing is, the moment you go to ACAS, there is a stop of in relation to the time limit. So your time limit of 3 months does not start counting, right? So you bring the claim, there is a stop. At the end of the ACAS conciliation service, then your time will start counting again. You don't have that exact 3 months anymore. You will still have something like maybe a month or 2 months. It really depends. There are different ways they calculate how long you have left. But the key important thing is you have to go to ACAS, get a certificate. If there's no resolution to the dispute, they give you the certificate. Then you need to keep your eyes on the time limit after that. Yes.
And is there a fee payable?
To bring a claim, yes, you have to. For unfair dismissal, the focus is on unfair dismissal now. The fee is £250. That is a claim of fee. Some people might be eligible for fee remission or fee exemption. If you're on state benefit, not every state benefit, it depends. I think you have to be receiving something like job seekers allowance or employment and support allowance. It is also depends on whether it is income based or benefit based. They have different kind of ways they calculate these things.
What you're saying is that there is a possibility
There's a possibility
have a fee remission,
to have
i.e. you don't
fee
pay the
remission.
actual.
Yeah, that means you will not be required to pay the actual tribunal claim fee.
What happens if you lodge the claim 4 months after the relevant period? So let's say you were dismissed.
Yeah.
You've gone to ACAS.
Yeah.
The clock's stopped. ACAS haven't been able to resolve it. The clock starts counting again.
Yeah.
You wait a few more months. Then you issue the proceedings at the tribunal. What happens to the claim?
Then that means you are out of time. You might be able to apply for an extension to lodge your claim out of time. But you will have to give very, very good and strong reasons as to why you couldn't bring your claim within the time provided. And they're very, very strict about that. So the best thing is don't even try to miss the time limit at all.
What would happen in the case, for example, I was going to bring the claim, but then I felt very, very ill, and I've been bedridden, and Is it possible
those are the usual acceptable reasons that the tribunal have found credible. Health reasons. I had to go out of country for some emergency situations. Maybe I had to attend to my very sick parent or grandparent. Yeah, those kind of excuses have been accepted by the tribunal. But again, as I said, you have to provide very good and strong reasons as to why you couldn't bring your claim within the time limits.
You mentioned earlier that the application has to be made, or the claim has to be made within 3 months and 1 day.
Yes.
Minus
1 day.
So what happens if I presented it after 3 months, but 3 months plus the 1 day? Are you telling me the tribunal won't accept my claim because of 1 day?
They are very, very strict. I can tell you that they are very, very strict. 1 day. These are the things that I've seen before. 1 day, they will throw it out. Of course, you can then make an application for extension. Well, they want to listen to your reason as to why. Look, I've done a case before. Well, the case came over to me after the guy tried to do it by himself before. His reason was I was looking for legal advice. I was looking for legal representation. In fact, I went to the Citizen Advice Bureau. They referred me to somebody else. They referred me to another place. So I was looking around to see if anybody could help me, that is why I couldn't bring the claim on time. But the thing is, it actually did a day late, but the tribunal still rejected it. It then had to start providing reasons, excuses, in its application for an extension as to why the claim should be brought out of time. In that particular case, the tribunal wasn't really impressed, but and then the state did not allow his claim to proceed because you had ample time. 3 months is quite sufficient time for anybody to seek and obtain, they said, legal advice and representation if necessary. Yeah.
All right, so the key thing is that if you do have a claim, make sure you bring that claim within 3 months minus 1 day, and the tribunals are extremely strict about that. Now, how does somebody go about making this application? Oh, sorry, I keep saying application. Making this claim.
Yeah.
Where do they go to?
Everything is now mainly online based. The claim form is online. You can still do the paper one, but in fact, the tribunal actually likes people to do it online as well. So you lodge your claim online. If you have to pay, you pay online. If you have to apply for fee remission, you apply for fee remission online. You submit your claim online. The process starts from there. Because your claim form will be sent to the other side. The other side will also lodge their response online. They will send you a copy of the employer's defense, and the process just kicks on from them. But lately, everything really happens online now. In fact, communication between you and the tribunal also takes place via email.
Thank you very much for watching and listening. Thank you to Lawrence for coming again and helping us out explaining unfair dismissal. If you have any queries or particular inquiries in relation to anything you've heard on this show, please email info@ojnsolicitors.com or contact any of the numbers that you'll see on the screen somewhere around here or there. I'm not really sure where it will be on the screen. You can search us on Facebook. All you need to do is type in Legal Peppersoup on Facebook. You can find us on Twitter @Legal Peppersoup. And remember, ignorance of the law is no excuse.